Good evening. I'm Tanya Bastian Galanis, Principal of the Eugene DePuch Law School. I will establish the protocol by welcoming our distinguished guest of honor, the Honorable Sir Dennis Byron, Chief Justice of the Bahamas, the Honorable Mr. Justice Sir Brian Murray, Queen's Counsel, Attorney General of the Bahamas, Senator the Honorable Carl Bethel, Queen's Counsel, President of the Court of Appeal of the Bahamas, the Honorable Mr. Justice Sir Michael Barnett, President of the Caribbean Court of Justice, the Honorable Mr. Justice Adrian Saunders, and judges of the CCJ, Justices of the Court of Appeal and Supreme Courts of the Bahamas, judges of our regional courts, Chairman of the Council of Legal Education, Mr. Reginald Amor, SC, Attorneys General of the region, principals of the law schools, and other members of the Council of Legal Education, Acting Senior Tutor Clive Guy and faculty of the Eugene DePuch Law School and staff of EDLS, and of our sister law schools, faculty and staff of our sister law schools, President of EDLS's Students Association, Mrs. Shanika Carey, students of EDLS and of our sister law schools, EDLS alumni, colleagues, friends, and supporters of the Eugene DePuch Law School. Hello and good evening. At the inaugural distinguished lecture presented in 2009 by Sir Orville Turnquest, former Governor General of the Bahamas, Sir Orville recounted the importance of law in developing orderly societies, and he spoke of the need for lawyers to be responsive to the requirements of an evolving society. Sir Orville and his former law partner, the Honorable Eugene DePuch Queen's Counsel, after whom our school is named, both brilliant advocates, were committed in their quest to serve their communities in the practice of the law. They were as committed to serve as civic and community leaders to ensure that our societies and our peoples are sufficiently equipped to embrace change and to themselves be change agents. One of the objectives of this lecture, named to honor the memory of Mr. DePuch, is to treat with and increase awareness around issues that touch and concern social advancement within a legal context. It is interesting to note that the last three presenters of this lecture use the word change in their chosen topics. And here we are now at a new frontier. The events of the past 12 months have undoubtedly caused, dare I say, all of us to shift, to redirect, refocus, to implement change, to innovate. I'm excited that some of the innovation that EDLS has accomplished in the past year enables us to present this lecture virtually to friends at home and across the globe. Welcome, and thank you all for being here. I trust that you enjoyed tonight's lecture. It is my pleasure now to invite Mr. Clive Guy to introduce our guest of honor. Mr. Guy.
Thank you very much, Principal Galanis, and good night to all. Principal Galanis having established protocol. I greet each and every one of you located in the Bahamas, throughout the region, and wherever it is that you have tuned in this evening. It is my distinct pleasure to have been given the opportunity to introduce one of the persons I consider to be one of my mentors, who I would love to emulate in all he has done and achieved. That is our presenter tonight, the Right Honorable Sir Charles Michael Dennis Byron, Sir Dennis, as he's fondly known by all that have encountered him. Sir Dennis was born in Basseterre, St. Kitts and Nevis in July, and at a very young age, he won the Leeward Islands Scholarship and went on to read law at Fitzwilliam College, Cambridge University, from where he graduated with both an MA and an LLB. In 1965, Sir Dennis was called to the bar at the Honorable Society of Inner Temple as Barrister at Law of the High Court of Justice in England. During his extensive career in the legal field, Sir Dennis worked in private practice as a barrister at law throughout the Caribbean, with chambers in St. Kitts, Nevis, Anguilla, and from 1966 to 1982, before being appointed as a judge of the High Court, he had an extensive practice throughout the Caribbean. In 1982 to 1990, Sir Dennis served as a High Court judge of the Eastern Caribbean Supreme Court, with special assignment as acting Chief Justice of Grenada in relation to the Maurice Bishop murder trial. Those of us of some vintage are quite aware of how important and landmark making that trial was. Sir Dennis, of course, acted as Chief Justice of the Eastern Caribbean Supreme Court from 1996 and was confirmed in April of 1999. During his tenure as Chief Justice, Sir Dennis led the Eastern Caribbean Supreme Court Judicial Reform Program, which included the establishment of a code of ethics for judges, the implementation of new civil procedure rules, and the OECS were quite ahead of the rest of us in the region in that, and the establishment of a Judicial Education Institute, among other innovations. In 2000, then Justice Byron was knighted by Queen Elizabeth II, and he was appointed a member of Her Majesty's Most Honorable Privy Council in 2004, making him only the second National of St. Kitts and Nevis to be so appointed. In 2004, Sir Dennis was also appointed as an honorary bencher of the Honorable Society of the Inner Temple, while serving as Chief Justice of the Eastern Caribbean Supreme Court, a position from which he later retired. Upon the invitation of the then Secretary General of the United Nations, Kofi Annan, Sir Dennis became a permanent judge of the United Nations International Criminal Tribunal for Rwanda, ICTR. Sir Dennis was elected president of the tribunal in 2007 and re-elected for a second term in 2009. And as president of the ICTR, which was in Arusha, Tanzania, Sir Dennis was also therefore an Under-Secretary General of the United Nations. As a result of Sir Dennis's precedent-setting judgment, rape is now considered a crime of genocide. And we had the pleasure of being hosted by Sir Dennis and Lady Norma and the judges of the tribunal in Arusha at the Commonwealth Law Conference in Nairobi, Kenya in 2007. It was an amazing job. Sir Dennis is particularly interested in judicial education. He has held the position of the president of the Commonwealth Judicial Education Institute, and the Eastern Caribbean Supreme Court Judicial Reform Program had its genesis and development under Sir Dennis's leadership. Sir Dennis has many publications and has been a keynote speaker and guest lecturer at renowned events and conferences across several continents. He also holds the first Yogis and Kedi Chair in Human Rights Law at Dalhousie University and was made an honorary fellow of his alma mater, Fitzwilliam College of Cambridge University. In mid-March 2011, Sir Dennis was appointed as president of the Caribbean Court of Justice, the CCJ, and had the pleasure of being sworn in his native St. Kitts. He retired from this job at the CCJ in 2018, but Sir Dennis did not rest there. He was later appointed as the chairman of the Commission of Governance established in 2018 by the Chancellor of the University of the West Indies to review the university's operations. And in 2019, Prime Minister Roosevelt's Carrot of Dominica announced that Sir Dennis will serve as the sole commissioner to advance efforts towards electoral reform in Dominica. All of that being said, I think Sir Dennis will agree with me when I said his greatest achievement, he is married to Lady Norma Byron and is the father of 4 children. With all of that. So I'll invite Sir Dennis to speak now. When Sir Dennis is finished, then we will take questions and answers, and I will ask you please to post your questions in the Q&A box, and they will be ferreted to Sir Dennis. So Sir Dennis, the floor is yours.
Thank you very much. Good evening to everyone, including all of the honorable and distinguished personages recognized by the principal of the law school. I must confess that after the type of introduction to which I was very enthusiastically given, I feel tempted that while you still have a good impression of me, to say thank you and end my presentation. But I know I cannot do that because I was really delighted that the Eugene Dupuch Law School invited me to give this 2021 distinguished lecture. As the principal noted, I doubt that it would have taken this form, utilizing advanced technology, about which I'm going to speak, if it had not been for the COVID-19 pandemic, which one commentator had indicated took only 25 days to introduce reforms that we've been speaking about for the last 25 years. Now, this law school has earned its reputation as one of the leading law schools in the Caribbean. And if I might be permitted to quote its distinguished principal, Tanya Bastian Galanis, the school empowers students to become flexible thinkers and problem solvers who will thrive in the 21st century. Now, that commitment fits well with my effort to describe the new frontiers created by artificial intelligence and ADR. And as this is part of the graduation exercises of the school, I really trust that your graduating class will encamp itself at the new frontier. I had the good fortune to also deliver the graduation speech for the 2020 class of Hewarding Law School. And in that speech, I also discussed the approach to intelligent solutions using artificial intelligence. It's really apparent that information and communication technologies have made an indelible mark on the justice landscape, from electronic filing and case management systems to entirely virtual hearings and court proceedings. Technology-enabled innovations have created opportunities and reformed entrenched traditions and practices in ways that were once unimaginable. Changing and emerging technologies also have considerable relevance to the continuing evolution of ADR processes. It has been estimated that more than 1 billion transactions now take place online each year. The notion that our current inefficient human-based resolution processes can be sufficient to resolve all these solutions indefinitely into the future strains credulity. We are already surrounded by examples of how easily faith in our ability to be fair and impartial arbiters can weaken under the strain. And it is undermined even further by what science and research continues to reveal about how our brains work. Meanwhile, computers continue to become more powerful and more deeply integrated into our everyday lives. It stands to reason then that if current trends continue, computers will one day be better at fairly resolving our disputes than we are. So herein lies the opportunity for the Caribbean. And in the context of empowering flexible thinkers and problem solvers who will thrive in the 21st century, I posit the question: will we in the Caribbean make artificial intelligence our frontier? Or we will continue to be content to receive its benefits from non-Caribbean sources. ADR is already benefiting from databases gathering and classifying precedents in arbitration awards using very sophisticated search engines. The possibility of virtual hearings with 360-degree scan of the room where witnesses testify, and various certification softwares. These developments have become necessary to maintain the advertised advantages of ADR as an efficient, cost-effective, and a timely dispute resolution service. As time elapsed, like the court systems, it started to become susceptible to increased complexity, both of procedural and of substantive nature. And costs and time for resolution have continued to escalate. This new frontier of artificial intelligence promises more rapid and efficient resolution of disputes, and therefore improvement of access to justice. One of the tools that it provides is the increased likelihood of settlement. This possibility is generated by a sophisticated synthesis of past precedents that are likely to be followed in any given case, and enables the prediction of outcomes. The Harvard project in the field of investment arbitration is projected as a potential game changer with significant impact on the economy of legal services and timeliness of dispute resolution in this field. A leading online publication, the Global Arbitration Review, reported that the dollar value of pending cases of their top 30 ranked firms is over $2 trillion. Now just imagine the value of a product that will help to resolve these cases faster than the current best practice estimates of 12 to 18 months. So again, I posit the question, whose frontier is this? Why shouldn't the Caribbean flexible thinkers and problem solvers who will thrive in the 21st century not take that frontier? Artificial intelligence impacts on substantive issues and helps to produce higher quality of decisions and enhance the development of a more coherent body of case law. And with permission to the President, I must reflect that the Caribbean Court of Justice has been at this frontier. The idea that we must develop our systems using expertise from the region who would customize the results for the improvement of our societies prompted the Caribbean Court of Justice to sponsor the establishment of a unique nonprofit corporation under the name of Apex to develop and support technologies for the improvement of the quality of justice delivery in the Caribbean. When I addressed that other law school graduation, I was pleased to be able to announce that the agency is headed by technology pioneer, Mr. Bevel Wooding, a relative of the legal pioneer, Sir Hewing, after whom the school was named. So I would just like to recall that Apex created and installed the high quality technology employed in the Caribbean Court of Justice, a platform called Resolve to support mediation and arbitration, and is currently rolling out a tool called Practice to support the legal practitioners within our region. These solutions were created in the region by Caribbean talent to world-class standards. These solutions are tangible demonstration of our capacity to shift from being mere consumers of external products to serious producers of intellectual property tailored to the needs of our region. This technology has helped to develop Caribbean jurisprudence and to make it more accessible, transparent, and exhaustive. One of the tools it uses was the digital recording of court proceedings and making the digital record the official court transcript. This is a tool that we have been advocating to judiciaries throughout the region, and it has many benefits, including taking away the slow preparation of transcripts as excuses for delay. These digital transcripts contain the whole of the proceedings. They are put online on the court's website contemporaneously and have remained accessible to the extent that one can review any case heard by the CCJ from its inception, free of cost. The judgments of the court are as accessible on the same website. We must remember that technicity and substantial issues are interconnected. The development of Caribbean jurisprudence includes the development of the related tools that help to create it. The vision of integrated social and economic development given us by the Caribbean community in the revised Treaty of Chaguaramas includes the preference of Caribbean products and the development of a Caribbean expertise, since both the technical expertise and necessary experience can be found within our region. I must reflect my sorrow that the core technology, which was developed by Caribbean expertise and deployed with success in the Caribbean Court of Justice, revealing access to a new Caribbean frontier, has not found acceptance by all Caribbean judiciaries, some of whom still find refuge in relying on foreign court technologies, often funded by state donors who profess interest in our development while undermining it by refusing to support the development of Caribbean technology to support the development of our justice sector. I suggest that the existence of the CCJ at the regional level, combined with its systematic recourse to artificial intelligence, made possible the development of a Caribbean jurisprudence that has international visibility. Now, when you're thinking of other frontiers in the field of ADR, we have to consider how do we look at things. Now, within our region, there are several international arbitration centers. These are all small centers supported by small populations and resource bases, which inevitably reduce the prospects of development. This is a reality which the visionary founders of the Caribbean community rationalized in the revised Treaty of Chaguaramas, which encouraged the development of economies of scale, which will at least reduce inequalities as we compete in the global arena. As of today, there are 4 main international arbitration centers in the region. The British Virgin Islands were the first to establish an arbitration center in 2013 with the BVI International Arbitration Center. In 2015, in Jamaica, the Mona International Center for Arbitration and Mediation was launched, and it was later rebranded as Jamaica International Arbitration Center. Barbados established the Arbitration and Mediation Court of the Caribbean in 2018. The Cayman Islands, with its Cayman International Arbitration Center in 2019, is the latest addition in the region. Bermuda and the Bahamas have announced their plans to establish their own centers. Now, the population base for all of this is in the region of 5 to 6 million people. When one looks at the global picture and one thinks of how these centers are competing, we have to reinvent the David and Goliath story. But there are so many Davids in our small arena competing with each other rather than combining forces to deal with the big world out there. So I regret the need to comment that the multiplication of these local arbitration centers overlooked some of the fundamental obstacles to a coherent development of ADR culture in our region. As of now, there is not full regional compatibility of our arbitration legislations. Either internally harmonized or compatible with international standards, and more specifically with the UNICITRAL model law. UNICITRAL is the acronym for the United Nations Commission on International Trade Law. It has been fulfilling a much needed role in creating certainty in international arbitration. Hand in hand with it, in fulfilling this role, is the New York Convention on the Enforcement of Arbitral Awards. In the Caribbean region, over time, many countries were and still are plagued by outdated and incoherent British-based arbitration laws. It has been recognized by Caribbean scholars that the UNICITRAL model laws and the New York Convention are important tools for legal reform. So what has happened? Most countries have chosen to ratify the New York Convention. Out of 156 parties, 16 are Caribbean countries. Suriname in 1964, Trinidad and Tobago in 1966, Cuba in 1974, Bermuda in 1979, Belize in 1980, Cayman Islands in 1980, Haiti in 1983, Dominica in 1988, Antigua and Barbuda in 1989, Barbados in 1993, St. Vincent and the Grenadines in 2000, Jamaica in 2002, the Dominican Republic in 2002, the Bahamas in 2006, the British Virgin Islands in 2014, and Guyana in 2014. The picture is not much different with the adoption of the unilateral model laws. The arbitration laws of such countries as Barbuda, Antigua and Barbuda, Dominica, Grenada, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, are based on the English Arbitration Act of 1950, which I must mention has in fact been upgraded to a modern arbitration law in 1996. And our Caribbean countries, as I mentioned before, those countries that I mentioned before, have yet to adopt the unilateral model law of 1985 as amended in 2006. For instance, in Jamaica, it wasn't until 2017 that a new revised Jamaican Arbitration Act based on the unilateral model law was enacted. Certainly, universal regional modernization of arbitration laws and the adoption of the New York Convention is a frontier we must achieve. I also include in that the concept of harmonizing our commercial law and arbitration laws to add certainty to trade practices and the management of trade arrangements within our region. Another frontier is the implementation of the structures foreseen by the revised Treaty of Chaguaramas and the resolution of interstate disputes within the CARICOM region. Now, it should be noted that the structures addressed in the revised Treaty of Chaguaramas only deal with disputes relating to the interpretation and application of the treaty. Other disputes between member states are to be resolved by other means. And there have been precedents for this, as there have been arbitration procedures between Suriname and Guyana relating to the delimitation of maritime boundaries, as well as between Trinidad and Tobago and Barbados, relating to their claims to the exclusive economic zone and the continental shelf between them. Now, the revised Treaty of Chaguaramas envisaged that interstate community disputes should be resolved by ADR before resorting to litigation, and provided for notification of such disputes to the Secretary General and the development of administrative structures within CARICOM which have not yet been put in place. At one time it was thought that there was little appetite for interstate disputation in this area. But there's currently pending the first interstate community dispute before the Caribbean Court of Justice. Belize brought proceedings against Trinidad and Tobago, St. Kitts and Nevis, and CARICOM itself in relation to non-compliance with preferential trade agreements in relation to Belizean brown sugar exports. The relevant point for our discussion is that the court ordered discontinuance of the case against St. Kitts Nevis on the filing of documentation which revealed that Belize and St. Kitts Nevis resorted to ADR on their own accord and reached a settlement of the dispute. So this is certainly another frontier to ensure that the administrative structures foreseen by the revised Treaty of Chaguaramas is put in place. Moreover, there must be a concern about the lack of coordinated approach at the regional and international levels, which threaten the visibility of the Caribbean region in international fora, including those relating to ADR. Because the Caribbean states are underestimated in the global fora in the field of ADR, such as the UNICITRAL, which has been commissioned to set up a working group in the field of investment arbitration to redefine the procedural framework of investment arbitration. Only this week, I have had first-hand experience of this, as I attended the meeting of the UNICITRAL Working Group and noticed that not one Caribbean state was represented. My attendance was not on behalf of a state, but on behalf of an NGO, OHADAC. Now, the practitioners in the region who are expecting that they will become a part of the international arbitration community are handicapped when our states are not represented at the regulatory fora. It is also a fact that Caribbean arbitrators are underrepresented in panels of arbitrators of global institutions. So the challenges faced by the region are insufficiently understood, and if not addressed, could negatively impact on the attractiveness of the region to foreign investors. So I suggest that another frontier must be the participation of community states in these fora, establishing greater bargaining power in this field. Now, having said that, I must recognize that the region has made a significant breakthrough with the election of the distinguished and learned Jamaican attorney, John Bassey, as the incoming global president for the Chartered Institute of Arbitrators. This is the attainment of a frontier, which I am sure he will leverage to raise the visibility of the Caribbean in ADR service, as he fulfills his promised mandate to expand ADR in jurisdictions where it is currently an underdeveloped option, and to enhance its appeal in jurisdictions where it is already developed. In sum, I think that there are many advantages to be gained from integrating our efforts. And perhaps even to developing regional centers, which could make the right use of artificial intelligence to bolster the emergence of a coherent ADR culture in our region. One important option is the OHADAC, a body which is in the final stages of preparing for its launch. It would have the opportunity to gather Caribbean expertise under its umbrella and could lead to the sharing of best practices, coordinating expertise at the regional level with ensuring economies of scale, increasing the transparency and attractiveness of the Caribbean business environment for non-Caribbean investors, and help to foster the emergence of a more visible group of highly qualified ADR professionals in the region. Now, as I mentioned earlier, I represented OHADAC at the Unicitral Working Group meeting, which is currently in progress. In fact, it will not end until tomorrow. I was particularly pleased that when I made certain comments on the lack of Caribbean representation, there was an immediate reaction from Dr. Leviticus Jules of the OECS. And despite the lateness of the applications, we were able, with the help of OHADAC, to gain admission for the OECS into this forum, where it is being ably represented by Dr. Genevieve Remy, an OES citizen and a senior lecturer at the Cape Hill campus of the University of the West Indies. So, as we collectively close in on these new frontiers, it is well to appreciate how things have changed. There was a time when technology was perceived as cold, impersonal, or dehumanizing. Arbitrators and mediators once resisted the idea that computer algorithms had any useful role to play in helping disputants find solutions to their disagreements. But how times have changed. Technology is now more accessible and integrated into our lives. And we now use technology in ways we never would have considered a short decade or so ago. People take to the internet to find their love, to select a church, to choose the best school, to seek out a lawyer, dentist, a physician, or even an arbitrator. The modern generation is even more comfortable as they seemingly share all of their life happenings, the good, the bad, the ugly, on social media. In short, people have now come to trust information presented to them by an algorithm. Perhaps even more than the trust information presented by a human. How times have changed. And so, Madam Principal, I hope that I have persuaded you and challenged your graduates that there are new frontiers for the flexible thinkers and problem solvers you have released to thrive in the 21st century. Thank you.
Thank you very much, Sir Dennis. Of course, as Principal Galanis, who will come on the screen very shortly, let you know. Indeed, our class will be graduating later this year, so they're not quite out the door yet, but it is good that you have given them the challenge so that while they're still with us, they will know when we teach them ADR, because we do have an ADR clinic that's run by CARB in the Bahamas, that indeed they're preparing themselves in so many ways for the future that you have outlined, and that they can actually be shapers of the future and not just merely persons who consume whatever else is left there. So I have indeed opened the question and answer box where I'm asking persons to please place their questions so that we can channel them directly to Sir Dennis. And Sir Dennis, there's a question already for you. So if I may, with your leave. And the question that is being asked, what are some of the governing principles for the development of AI and ADR in the Caribbean with respect to its ethical use in judiciaries? Do they align with a set of guidelines bespoke in the Caribbean for the efficiency of justice? So it's a question literally about the ethical use of AI ADR in judiciaries and whether they align with international guidelines or other guidelines set out.
Well, there are different thoughts that immediately spring to mind. As you mentioned, I am part of the Commonwealth Judicial Education Institute. And over the last year or two, we have already been exploring the use of artificial intelligence in judicial training, judicial education for judicial ethics. So we have been developing programs to use artificial intelligence to assist in ethical training. Now, it's very interesting that, as I was mentioning earlier, the importance of regional and international association with the standards and the absence of a Caribbean center means that the ethical standards are fragmented in terms of the various entities within our region. But it's very interesting that at the UNICITRAL meeting I've been attending, in fact, one of the issues that are being presented for the adoption of the international community is an ethical code for arbitrators. And that is an agenda item that's the agenda item for tomorrow. So there is being considered at the international level standards which are going to be offered to us all to by which we can establish our own ethical standards if we want to do it regionally. And so there are steps being taken to internationalize the ethical standards which will govern ADR practices and the use of artificial intelligence within them.
Thank you very much, Sir Dennis. And interestingly, as you mentioned, the small ADR centers, one question that immediately popped up, and I'll read it. The question is, the person says, I found the comment about many small ADR centers interesting. Does Sir Dennis consider that each of the centers may each have something different to offer, considering that ADR is a complement to existing industries?
Well, the answer is obviously yes. One of the thoughts I have, as I discussed one thought already in my presentation, that I thought that when one is thinking in terms of international arbitration, that being backed by a larger base improves the ability to compete with the major arbitration centers in New York and Paris and London and so on, Singapore and so But in terms of the reflection that is being raised, one of the thoughts I have been having is that in all of our countries in the region, they have courts have been fighting delay. And the use of ADR is a complement to the judicial process, which could aid in the reduction of the backlog of cases which exist. And I have thought that in developing a culture, so I've spoken about the culture of ADR in our region, that the increased use of ADR in the resolution of commercial civil disputes in our regions would certainly improve. Now, I tried to get some statistics as to what is happening in the various arbitration centers. But what has happened is that the use of ADR in our communities has been ad hoc and has not been passing through the centers. So the centers do not have a handle on the extent to which ADR is being used in each of our countries. So that's another point that I am interested in encouraging, that there's a value in the maintenance of statistical information about the way ADR is being used, its frequency, its development. And so the expansion of the operation of these centers to encompass domestically the domestic arbitration would also be, in my view, a new frontier which could improve our services in our region.
Thank you very much for that, Sir Dennis. So the question that comes up now is, will the incorporation of AI in ADR proceedings result in a reduction of jobs within the ADR sector?
It's very interesting that this question always crops up when it comes to advocating the increased uses of technology. Now, basically, what I say to this is this, right? Now, I have before me the presentation I made at the Hewlett Law School, where I addressed that thought. And what I was saying was this, that the time that ADR saves in the hard work of research frees up the lawyers to spend more time in strategic thinking, so that the services which ADR takes away creates opportunities for us to use our time in more productive ways. So I do not see ADR as a challenge to increase to our earning power. In fact, I would rather think it would enhance our earning power, because if AI really succeeds in making the process more efficient and shorter, it means everybody could have larger caseloads.
Okay, so Dennis, I like how you said that lawyers, we always find a way to adapt. I would like to think of us more chameleon than some of the words that have been referred to us as a profession. In that sense, Dr. Peter Maynard has asked, do you see a role for court-annexed arbitration, or is such a role limited only to mediation?
The answer is yes. I think it's being used. I know that in Belize, the civil procedure rules have been adjusted to incorporate court-annexed mediation. And I recently came across, now I'm living in St. Lucia, and it recently came to my attention that the High Court has been making orders with the consent of litigants to have matters assigned for arbitration. So it seemed that the results of those orders were well received by the litigants, and it assisted the court in having matters removed from its calendar, freeing up the judges to take on other work. So the answer is yes. I think there's room for coordinated mediation. More coordinated arbitration.
The next question I have, because we have several of them coming up, Chairman Reginald Lombard has asked, if AI is indeed to be the new frontier, does Sir Dennis have any thoughts and comments on the question whether the provision of national internet, therefore access to and use of AI, must be an affordable public utility?
Well, one of the things that my reading on the subject has revealed is that the cost of technology with its greater use is continually going down. And so even if the state itself does not sponsor the use of internet services, the wider utilization of it by our population will itself be a market factor, which will drive down the cost. But if I were living in utopia, my answer to President Abbas' question would be yes.
I think most younger generation would absolutely love that. Free access to the internet. So the question has been asked. So Dennis, based upon your global experience, 1, what are the emerging areas of legal practice for Caribbean lawyers? And 2, what area of law would you advise young lawyers or students to consider as a career?
So that question plays into a peeve that I used to have while I was at the ICTR, because we had adopted a program, an internship program, and one of its objectives was to provide an opportunity for third world law students to get exposure to opportunities for international criminal law practice. But consistent with what my complaints, this opportunity was not taken up by the Caribbean. In fact, a couple of the better interns that we had were Caribbean people, but they were not coming to ICTR from any Caribbean institution. One came from Harvard, Trinidadian. Our Antigua representative came from London University. And I recall writing our Caribbean institutions. But of course, the issue was who pays and how is it afforded? But I have thought that there are opportunities in international law practice. And there have been many Caribbean people who have done quite well in this area, in different issues in the law of the sea, set up somebody in the International Court of Justice, and that sort of thing. There's no area of law, which is not open to young criminal lawyers. And one of the benefits of the new technologies is that the utilization of our new technologies and AI, if the AI systems were adequately embraced, our small law firms or single practitioners in the region would find that the playing field between them and the large law firms is evened up quite a bit. So I do not think that there's any handicap to the young Caribbean practitioner in dreaming big in terms of what his practice can be, so long as he or she is willing to embrace the benefits of the new technologies.
Thank you very much, Sir Dennis. And along that very line, the question has been asked, with artificial intelligence integrated into human processes touching ADR, is there a safety net? AI is evolving continually to not only replace arbitrators, but to developing itself. Or maybe the person asks, are they understanding this wrong? I guess that fear of the machines, if I were to summarize that. But the question being asked, is there a safety net involved?
Well, I don't know how to answer that question. You see, there's a scientific element to the question, which I'm not capable of answering. But as of now, ADI is still a tool which we use. So to some extent, we still have some control over the uses to which we put it. As far as I can see, that within the our field of endeavor, what artificial intelligence is doing is really improving things that we have been doing all along. So, for example, the searching capacities that artificial intelligence uses is an enhancement of our keyword searches. The ability to scan documents is an enhancement of facilities which we are currently using. So what has been happening now is that services which we have been using in an elementary fashion have now been improved. I was able to see the use of artificial intelligence in supporting judicial decision making a few years ago when I was in South Australia, where they had developed quite a sophisticated system supporting the sentencing in criminal trials. And it was very fascinating to see the extent to which it was being utilized. Because the machines, as you call them, were able to provide information which was based on information which it was given. So, for example, it could access information based on the characteristics that were of the offender, characteristics of the offense, characteristics of the victim. And it could access decided case law on these issues very rapidly. and synthesize the results and present them to the judicial decision maker. At the end of the day, this information was used by the judge to make his decision. I have not yet come to fear artificial intelligence as a usurper.
Thank you very much, Sir Dennis. The question I'm being asked by Ten Houston, I believe, out of Guyana. Access to technology has been part of the right to freedom of expression in most Caribbean constitutions. Should access to technology be also included as part of the right to access to justice as well?
Well, I think so. You see, I think it's both a right and a duty. There were some years ago, you see, and so the question really is how you define where the right comes in. So for example, if you were a litigant dealing in a court that was into e-filing, I think the court has a duty to provide assistance to assist the litigant to manipulate the system. So in that sense, I would think that the litigant has a right to access to justice, to access to the technology, to access justice. Without that, they can't access. So I'm not quite certain how far learned counsel wants to go with this question of rights. But if I might just tease you a little bit with a comment I used to make. Because when we were discussing in my early days in Eastern Caribbean about the improving or compelling or requiring the use of technology in our judicial systems, questions were raised. Well, what happens if a lawyer doesn't have a computer? And my answer was that he should not be allowed to practice.
Ouch. I had to say ouch for that one. I will abuse myself a little bit and just ask a very quick question. I'm asking it because I remember, I can speak her name, Justice of Appeal Lucky from Trinidad and Tobago, the Supreme Court in Trinidad and Tobago, raised the question, is it the future of legal practice that if an attorney does not use AI in terms of whether he advises his client to settle using ADR or to proceed, etc., is there a possible ethical issue to arise? So if a judge, when sentencing or making a particular decision on admissibility of evidence, does not use AI, whether it be Vincent or Watson or whichever name, is there a possibility of a ground of appeal? And I was stumped for an answer. Is that the future?
Well, I don't know. The question had previously been asked the other way. Whether it was unethical for the courts to use AI. Now, that has been answered judicially, because there have been courts in America and in England and Australia which have decided that the courts can use AI. Now, Justice Lucky is now pushing it a little bit further and asking whether the courts must use AI. And I don't think we're at this stage yet, because the availability and accessibility to AI systems is still growing. But there may come a time when it is perceived that one cannot do one's job properly without using it. I'm not sure where that time is reached, in what countries or what court systems that time is reached already.
Thank you very much for that, Sir Dennis. So now I know what to tell Justice Lucky when next I speak to her. The question has been asked, incorporation of AI into ADR proceedings can be considered a huge or costly investment. do the benefits of AI truly outweigh the costs of it?
Well, the question is who is making the investment? You see, again, from my readings on the subject, there are the investments in AI are being done by specialists who then make the systems available to practitioners. And the practitioners, now, I saw some statistics when I was looking at the Harvard project. There were apparently they had a study which was examining the use of AI, and again, it was a little bit revealing that in their study, 90% of large firms, and by large, they define large firms as firms with more than 1,000 lawyers. 90% were using AI. Now, their survey also said that moderately sized firms, which were defined as firms with 50 lawyers or more, 36% of them were using AI. Now, it did not define, I didn't see the statistics for small firms or single practitioners. But I wondered whether the smaller the practice was, the less use of AI there was. When to my way of thinking, I would have thought that the less manpower you had, the greater your need for AI would be. Because I thought that that would be a way of leveling the playing field. If you had access to AI, it would enable you to compete more easily with larger firms. So in fact, I use the imagery in my address to the Juilliard Law School that that having let me see if I could find what I said. I said, if the challenge before our profession is a big tree, and you have collectively the small axe. My message is that as you have experienced during this last year, where you were able to adapt to the change in teaching, learning, and examination techniques that the corona pandemic created, now you must be ready to be part of the changing environment and landscape that artificial intelligence is making a reality. You have the tremendous opportunity to be the small axe which can shape the development of the future. So I would have thought, to my way of thinking, that access to artificial intelligence is a useful tool for small practitioners.
Indeed, Sir Dennis. So then the question that has been asked here is, do you think there's any focus or use for ADR in the criminal justice system?
Well, I think it has been used. It is being used already in many instances, where at certain levels, at certain levels of crime. You know, again, if you forgive me for using an extreme example. You know, in the Rwanda, after the genocide, there were the international tribunals only tried the most serious cases, but the And so we were dealing with the heads of state, heads of the senior people. But the actual perpetrators of the crimes were left for trial in Rwanda. And the traditional court system was a bit incapable of dealing with the mass. So they went to what was their traditional gacaca course, which was a form of ADF. And you know, it was very interesting that in many of the cases, the whole community was present. The relatives of the victims were present. The accused persons often came forth and said, I want to ask your forgiveness, but I did commit the crimes. And you know, in many instances, the punishment meted out by the court was a financial punishment. So the perpetrators of these crimes, including killing, were ordered to pay percentages of their income over extended periods to the relatives of the deceased. So even in extreme crimes of that nature, there are communities which have found use of ADF practices. Now, I would imagine that the practice in our society is more relevant to misdemeanors and smaller crimes.
Thank you very much for that, Sir Dennis. And as we wind down, I'll take this as the last question. The question has been asked, in light of COVID-19 and the acceleration of technology and removal of physical boundaries for meetings and trials, what is Sir Dennis's take on one, the future of courtroom trials, and two, the future of the CCJ in relation to same?
Well, the CCJ has already, long before COVID-19, been having virtual hearings. So the pandemic has probably just made everybody more aware of it. You know, I have often had the idea that when one is thinking in terms of expanding the operations of justice facilities, building courtroom structures is becoming less important than providing other facilities for court operations. So I'm not saying that courtrooms necessarily have already become anachronistic. That's not the point I'm making. But the point I'm making is that there is a wide variety of judicial processes that do not need a physical courtroom for the judicial officers to perform their duties and provide justice to litigants. So I can see that there'll be growing percentages of judicial service that are rendered without utilizing a physical courtroom. And I think that has already commenced.
Indeed, Sir. So I promised that would have been the last question, but I've been begged to at least by Tenny Houston to ask you this very quick question. Are there concerns regarding AI bias insofar as the solutions are not derived from Caribbean societies?
Could you repeat that again?
The question has been asked, are there concerns regarding AI bias insofar as the solutions that are in the system, in the algorithm, are not derived from Caribbean societies? And I'll append the second question to that. The second question, which I promise is the last, is the question of cyber attacks on AI, and can these affect the outcome, of course, if used in arbitration and other means?
All right. The second question is easier because cyber attacks is a feature of modern life which we have to live with. but the technologies exist to diminish the risks. And those technologies are known and available for use in court systems and arbitration systems. Now, with regard to the first question, that is what my thesis is all about. Why should we sit back and complain that algorithms are made by foreigners, therefore they're not suitable to us, when we have our own experts in the region who can develop our own algorithms? And my message to the, let me find the principal's words. My message to the flexible thinkers and problem solvers that Eugene Dupuis Law School is releasing on the world is, why don't you get involved in AI? I am very anxious that in our region, we stop being consumers of external technology and we start being developers and producers of it. I do not think that there's any difference in intellectual capacity, intellectual knowledge, which will make our experts less fit to do this than experts from other countries. And that is what I'm trying to say.
Thank you very much, Sir Dennis. Well said. And I think we will bring the question and answer portions, a portion of the evening to close. And dare I say, exactly where Sir Dennis started is where Sir Dennis ended, to encourage us to take up the mantle and to be leaders, not followers and mere consumers. So let our creativity and thinking caps, let us shape our destiny. This is a brilliant charge. This is a brilliant opportunity. Thank you very much, Sir Dennis. I will now call upon the president of the Eugene Dupuis Law School Students Association, Mrs. Shanika Carey, to give the vote of thanks.
With all protocols duly observed, a pleasant evening is extended to you all. On behalf of the principal of the Eugene Dupuis Law School, Mrs. Tanya Bastian Galanis, Mr. Clive Guy, senior tutor, the faculty, staff, and students of the Eugene Dupuis Law School, I wish to express my sincere gratitude to you, the Right Honorable Sir Dennis Byron, for your address on AI and ADR, the New Frontier. The 2021 Eugene Dupuis Distinguished Lecture was the first ever Eugene Dupuis Distinguished Lecture to be held virtually, and we are privileged that you, sir, were our guest of honor. Based on the number of attendees who registered and participated, as well as the number of questions posed following your address, I know I speak for most when I say your presentation was exciting, engaging, and very well received. I am confident that the insight you shared with us tonight on both artificial intelligence and alternative dispute resolution will be valuable to us as AI becomes more integrated into our day-to-day life and ADR gains greater prominence in legal practice. I wish to also express our gratitude to our distinguished guest. We are grateful that you were able to spend your evening with us. To our wider audience, thank you for attending and participating by way of posing questions in our first virtual Eugene Dupuis Distinguished Lecture. Your participation has made this event a resounding success. Once again, our profound thanks to you, Sir Dennis Byron, and to our gracious audience for the continued support of the Council of Legal Education and the Eugene Dupuis Law School. Good evening.
Thank you very much, Shanika. I will give Principal Galanis, and I know she's my boss, but I'm only giving her 30 seconds.
Thank you, Clive. I only need 10. I just want to reiterate our gratitude to you, Sir Dennis, and to thank our audience. I will challenge our students to rise to the to be able to embrace the flexibility that you've put out to them, and to hold on to all that you've said as they seek to solve the problems in our several communities across this region and beyond. Thank you very much, sir.
Thank you very much, Principal Galanis. So, ladies and gentlemen, Sir Dennis, invited guests, distinguished guests, this brings us to the end of this evening's session. Thank you very much, Shanika Carey from EDLSSC, our president. And of course, ladies and gentlemen of the audience, you, without you, none of this is possible. I thank each and every one of you for attending. Of course, Sir Dennis, I must say, give Lady Norma my regards, please. And everyone have a Everyone have a wonderful night, and I will say, as usual, get home safely. And if you're home, stay safe. Have a good night, everyone. Thanks again for attending.
Thank you.